Hi, I'm Dave Wurzel, and you're watching PHTV4, and this is Ask the Attorney. And this is a relatively new show, but a great show to kind of address some practical concerns or questions that come up. And obviously, we have an excellent opportunity here. We're speaking with Eileen Kerlin-Walsh. This is your area. This is your background. You can bring your expertise as a lawyer of your own business to this a variety of topics here we're going to take a look at.
Absolutely. Thank you, Dave.
Last time we talked about estate planning, and then that was for a different thing, but it was interesting because that topic kind of generated a lot of spin-off questions. It kind of came up later. I thought, boy, that was great. I learned a lot. And then I realized, well, maybe I had other questions came up related to that. And talking about estate planning, what about related to that is somebody in like a special needs situation, which adds a layer of complexity to what kind of help I might need or what the estate planning process might look like, right?
Absolutely.
Can you talk about like why that estate planning looks a little different or why we might need special help in that area?
Yeah. So let me start by saying I have learned a lot about human nature and about our society in 20 years of estate planning. And a lot of it is very, very positive. There is something that I've found a little bit alarming, and I think all of us need to realize more about our society in estate planning, is the degree to which we have many vulnerable society members. I would say, Dave, from my experience, that maybe 1 in 3 families needs, in addition to their ordinary estate planning, some special needs trust planning. Why is that? Between autism and children, which we are, I think, 47 in 100, those numbers are alarming.
I know they're high. Yeah, they've been going up.
They're high. They're high. My numbers may not be correct. I know they're high and they're going up. We have mental illnesses, often diagnosed in teenagers, late teenagers, 20. Those mental illnesses, either untreated, undertreated, or not recognized, often lead to mental illnesses, which lead to addictions. Addictions need special estate planning. And then we have dementia, early onset dementia, as well as later in life incapacity and Alzheimer's. So I determined that probably there was 1 in 3 in our society that fitted into one or some incarnation of those categories. I met a mental health nurse recently who said, oh no, it's closer to 1 in 2. Half of our society needs that extra little bit of help. Now, there are many, many resources that our vulnerable need in society, but when it comes to estate planning, there is so much we can do.
You know, as you're saying that, I'm thinking about like writing my own will and what that looks like and who I'm planning for. And then I started doing a mental survey of, our friends and family and who does this impact? And my thought was, and I don't know how often people address that issue. I mean, what are the risks? Let's do it the other way. So I'll spin it back the negative way on you. If let's say somebody doesn't have a lot of money, they don't have a lot of assets or equity, and they're thinking, all right, maybe I should do a will. Maybe they have somebody in their family who is a special needs person in some way, wherever they're at in some type of challenge. What if they don't do any plan? What are the risks in not doing estate planning as compared to somebody who maybe doesn't have that person in their life?
Yeah. So the additional risk for the family with that vulnerable member is that if they don't plan for that member, they're very likely to lose whatever benefits they might be receiving. So if without any planning, your assets would go to your heirs. So if mom and dad don't do any planning, what they have, it'll go through probate, it'll take longer, it'll cost more, but it will eventually, what's left will come to the heirs. Mm-hmm. So the heirs are their biological children. If one of those children has a disability, is receiving SSI, very, very common for disabled adults, is from Social Security, is receiving Medicaid for their healthcare needs, that inheritance, even if it's only $20,000 or $30,000, would interrupt those benefits. Many of the benefits available from state and federal government are income kept. Most of our vulnerable adults who receive these benefits cannot have more than $2,000 in their bank account.
That's incredible. I'm kind of shocked as you're saying.
Absolutely.
If anything, I feel like, this raises a major concern. So if you think at all that this could be an issue or you have someone in your family you're at all concerned about in this way, you need to address this very specifically, kind of aggressively, it sounds like.
Absolutely. And get those special needs plans into place. So it's not, the government actually wants us to take care of our vulnerable adults.
Right.
That's why we have special needs trust plans. That's why we have these laws in place. But we've got to get them in place in time.
Right.
So if parents, and Dave, one of the things you said about inadequate planning, what parents used to do before they would realize that special needs planning is an option would disinherit. If they were planning, they would disinherit maybe the disabled adult with an addiction or with Down syndrome and leave the extra money to the able family member because they knew that family member would take care of their disabled sibling.
Yeah.
That had so many vulnerabilities. One, of course, there's always the danger of commingling those funds.
Right.
The line might get a little blurry. But even with the best intentions, sibling could go through a divorce. Try explaining to a divorce attorney on the other side, oh, that's not really my money, that's for my sibling. Legally, it's yours and would be subject to marital split. There are a lot of good reasons not to do it that way.
Right.
Whereas if the family sets up a special needs trust in time, in place, and has any inheritance that's going to their vulnerable family member, go to a trust that's already been set up in advance. They build a wall around that asset, protected not just from the vulnerable adult who may not be able to manage that money, may dissipate those funds, may harm themselves, may be subject to predators, but they won't lose any benefits that they have tried. And it sometimes takes years to get these benefits in place. An interruption of Medicaid for somebody who's taken psychotropic medication is you might say, some of our viewers might say, well, what's the harm? Lose the benefits, spend the money, and then get them back again. We may not get them back again, and taking someone with mental illness off medication, even temporarily, is just a path we do not want to go down.
It's potentially dangerous, certainly potentially harmful. You're talking about quality of life, and I can see it's just kind of fraught with problems. And I wanted to add, so you're talking about a special needs trust, and again, I'd heard the term, I didn't know what it meant or why it might be necessary. Related to that, then again, it gets into, and you kind of mentioned this already, is then who's the trustee of that thing? I mean, how do you find that person?
Yeah, that's an art, and we can determine the trustee in one of two ways. And let's just say we have a nuclear family. I know everybody doesn't, but say it's mom, dad, and there are the disabled adult and there are siblings. If mom and dad are lucky enough to have an able sibling who would manage that trust, that's the ideal scenario. So now they're the trustee of the trust. They're the one who has the skills to manage the funds, and they would have instructions both from an attorney and through the trust on how to manage those funds for their disabled sibling. So typically, Dave, we know that you're not going to give at least more than $2,000 at any one time to the beneficiary of the trust. We also have to make sure not to give payments for a vacation or an electronic or some new clothes or the dentist. We don't give it directly to the person with the disabilities. The trustee makes those payments to the vendors. Again, keeping the money safe because does not belong to the beneficiary. It's for the benefit of the beneficiary, thus preserving the benefits in place. Now, if we don't have that family member or we don't have someone who has the skills, then there are always professional trustees. And any trust we ever talk about, this will always be an option. So if there isn't that trusted family member, we could make maybe the local bank or a small trust company or one of the big trust companies, depending on the degree of the assets and the degree of of administration that's going to be required. A professional trustee is always a great option, professional, won't be persuaded by emotion, is going to follow the law, but the one downside for most of our families is the expense, the cost. Many of the trust companies will take a percentage of the trust corpus, as we say up front, transactional fees, sometimes monthly fees, and can be a drain on the funds for our special needs adult unless we really do have enough to be able to absorb that kind of cost.
You know, I mean, as you're saying, I'm thinking about the level of concern a parent might have or a family member might have about what happens when I'm gone, right? And maybe there isn't like that big family around or not that trusted person that you feel like, well, this person can step in, or maybe whoever you'd like to can't. Yeah. So maybe that, now I understand why that is such a critical option for somebody.
Absolutely.
Including whatever the cost is. I'm assuming this has to be drawn up by a lawyer. Can you create a trust like this without a lawyer? Is that?
Well, this is the one thing, and you know I'm not a huge fan of going to LegalZoom and things like that, because I have never seen anyone come in with an estate plan through one of those services where they get it right. Even someone who's very, very capable and able in their profession, because you're looking at this for the very first time.
Well, I was going to say, there's got to be a personal connection too, right? Like I have a unique situation, so if I can talk to you, and that's how we take care of those specific nuances or subtleties of what my situation is with my family or friends or whatever, right? I'm sorry to...
No, not at all, Dave. So it's, if there's a trust that you're not going to skimp on, make it your beloved family member's special needs trust. Because they are going to be examined by federal and state agencies who are going to make sure that they are correct, because if they're not, then we're going to lose the benefits. That's why you have to be absolutely 100% sure that they're set up correctly. And if they are set up correctly, we don't even have a cap in Illinois. There's no cap. Any family member can leave money to these trusts. And mom and dad could create the special needs trust within their trust, or they could do what we call a standalone trust, where everybody else is getting taken care of through the family trust, but this special needs trust stands alone, has its own date, number, date, and then we can write letters to other family members who may be inclined to give some money for that family member, and everyone can make sure. Do you know, Dave, how many grandparents who, believing they're doing something really kind, even though they're leaving most of what they have to their own children, they will leave maybe 10 or 20,000 to each one of the grandchildren. And that money for a child with autism, or a teenager with a mental illness, or a middle years addiction, it can turn out to really cost a lot more than the 20,000. Maybe even interrupt benefits that we cannot ever get back. Now, all is not lost. Even if we're going through probate and the grandparents have done this and they've left a gift which is going to threaten benefit interruption, we do have some options. And this is not the show where we're going to talk about self-settled special needs trusts or pooled trusts. There are options.
Part 2 or part 3?
Yes, but those are what we call payback trusts. So if the money's already in your name, it's too late to get the degree of protection we would have gotten if it was what we call a third-party special needs trust. But we still have some options for how we can take that money, create some kind of a trust. But the big difference is, if our special needs adult dies, anything left in that trust goes back to the government. Whereas if it was created through the third party, meaning it never ever was in the name of the beneficiary, then when that person passes away, the trust maker gets to choose who the money would go. Would it be the other siblings? Would it be a favorite organization? You give yourself so much more choice and save so much more money when you plan adequately and timely.
I was going to say, based on what you're saying, I wouldn't want to try and plan this on my own, I think, or through a, you know, a website or something like that. You mentioned, I wanted to come back to a little bit, you started to talk about it, when that trust is set for that, you know, a person is managing a trust for somebody. So when they're managing that fund, are we talking about like they're buying their food, their clothing, helping pay for their home, their living situation,
Yeah.
all of it, any of it, certain limitations?
So that's a great question. And it gets right to the heart of what does special needs mean? Special needs does not refer to the disability. Special needs refers to needs over and above what is already provided by any state or federal agencies. So they're also sometimes called discretionary or supplemental needs, which gets to the heart of what the Special Needs Trust is. And special needs can have sometimes a little bit of a taint that families can be a little bit uncomfortable around. But if we understand that we're talking about needs over and above that already provided for, it helps us see that the wide array of services that these funds can be used for. Now, the one thing that the trust is very careful to lay out is that it cannot be used for anything that's already been provided. And for our disabled adults, if they have applied for everything that's available, they often will have Social Security benefits, they will have maybe housing benefits, help with your utilities, help with their food, help with their rent, all of those things, maybe even group housing. So if it's already provided for, then the trustee has to be very careful not to make payments for anything that's already, that's going to break the trust. It's everything else. Okay. So it's any medical or therapies that are not being provided. It's for maybe some sort of a special dietary need that's not provided for, something medical like dental or vision that's not being provided for. So it's a wide array, but the trustee of a special needs trust needs guidance, would need to know what they can use these funds for and how those funds are to be applied to the needs. Important
distinctions. And then you mentioned that, and as you were saying, I thought about it, and maybe, I don't know if we covered it completely, but we started to talk about what happens if the funds, like you talked about the funds going back to the state. And as soon as you said that from there, like, wait a minute.
Oh no, we don't want that.
We don't want that. So let's, unfortunately, the other part of it, what happens to like leftover funds, or what happens if that person is, they pass away, or maybe some other circumstance comes up? What happens to the trust then?
So the trust maker, if my clients are planning with me and they're planning their regular trust, they're planning the special needs trust, I ask them if there are funds left in this trust after the beneficiary passes away, who do you want them to go to? So they get to choose whether it would go to their other children. Now maybe everyone's gotten older, some of their children at that time have passed away, so we can use some of our lovely legal terms like per stirpes, and that it would go to children. And you know, so if we've gotten to the strata where, you know, this generation is starting to pass away, it could go to the next generation. So the money can be kept in the family. It can go sometimes to organizations. Like a lot of our clients love the Illinois chapter of ARC, which is an organization especially to help disabled adults.
Some charitable organization, whatever it is.
Exactly, or CERTOMA, or one of these organizations that has done so much to help disabled adults.
Okay. All right, I feel like we've covered a lot of ground here, and even still I feel like I understand now why it'd be especially important to use a lawyer to go through this type of planning. Final question I want to ask you, though, is like, are there any other situations or any other like advice that we haven't covered that you think people should be aware of in this situation, if this is part of the thing they have to plan or prepare for? Other factors they should consider.
Yeah, you just mentioned there, Dave, that it was just occurring to you how worrying it is for people as they get older, and now their disabled adult is getting older, and they start.
What's going to happen?
Yeah, what's going to happen? So the Special Needs Trust funding can go a long way to allaying the fears of how their loved one is going to be cared for. The other couple of things are to think about are guardianship and accommodation. So let's say we do have an adult with Down syndrome. Mom and dad have probably been their guardians from they were 18. Right. So if there is, and I know we're not all lucky enough to be in this situation, but if there is another sibling who, and sometimes the conditions of the estate planning are that maybe one of the other siblings gets to keep the family home as long as they do agree to be the guardian for the disabled adult. So sometimes we can make it more, we can encourage another sibling to be the one who is going to be prepared to be guardian. Now, guardian is not something that we determine through our estate planning. We can say whom we'd want to be the guardian, but if they've already been the legal guardians from that disabled adult has been 18, it's now time for them to start thinking about maybe adding a co-guardian to that county guardianship, or even a standby guardian. So if there is another sibling who's prepared to be the guardian, we could go through the process now with Cook County, Will County, wherever the adult is living, and have that person vetted, because we do need to be vetted in order to be a guardian and to be appointed.
And managing a trust, ultimately.
Absolutely. Right. And so what the judge does in guardianship, and boy, we could spend a whole show on guardianship. That is one area of care that we all want to avoid, if at all possible. But in a guardianship, a judge takes away, the law takes away the rights that most of us get automatically when we're 18. And they take that so seriously that if they're going to appoint you or me as guardian of a disabled adult, both of their person, taking care of them, and of their estate, their money, they're going to put us through, they're going to vet us to make sure that we're the kind of person that they would put in charge of this adult. So for my guardians, sometimes they're very surprised, because it's often such an altruistic thing to step forward, to agree to, and then to realize that the court is now going to ask them all kinds of questions about their background, criminal history, financial history, but it's something that the courts take very seriously. So to get back to your question, another thing the parent has to think about as they're planning for when they're gone is maybe adding someone as a co or a standby guardian legally, so that that person could step in right away. And then the last thing is accommodation. So if we're lucky enough to already maybe have a group home, that will continue with the guardian, whoever's been the guardian managing it, with whatever funds are available. Or it could be the family home, could be negotiated with other siblings in order to provide accommodation, or one of the other siblings agrees that they will take the disabled adult to live with them. And sometimes the disability isn't Down syndrome, maybe it's just vulnerability with a particular substance. So maybe then that disabled adult can live by themselves, but they're going to need to be monitored in their care. So accommodation, and even where the guardian and the trustee of the trust lives, all of these things have to be taken into consideration. If I could finish with one point, Dave.
Yeah, and one other little question.
Sure.
Right? I don't want to derail your thought. Are you good?
No, that's grand.
Well, the thing about, I want to clarify on accommodations, we're talking about living conditions, but it could be influenced by other factors, correct? Any type of accommodation for this person to live their life, right?
Yeah,
okay.
Yeah, where, I mean, where are they going to go when mom and dad are gone?
Right. Okay.
Yeah, it's that bold of a fact, which maybe I was trying to be really nice about. Oh. But when clients come to me, and this was the thought that I was going to finish with, this is so frightening for them, and something that's been heavy on their heart. And when they realize that they have the option of special needs trust planning, adding someone to the guardianship, maybe using their estate planning to compensate or almost reward someone who is prepared to take on the disabled adult in their life, the relief that they feel is palpable. It just gives them such a sense of peace and peace of mind, and it makes me realize, again and again and again, why I do what I do.
As we went through these questions, I thought about that, how stressful that could be, that uncertainty, that fear about what's going to happen, or will the person be taken care of. And I know we can't anticipate every scenario, but to think that you could address so much of it and have something in place that should protect people and help improve the quality of somebody's life, invaluable. Eileen, thank you very much.
Thank you,
I
Dave.
appreciate the opportunity to ask an attorney.
Thank you. Yes.
No, this is incredibly helpful. This is great information. So thank you.
Thank you.
I'm Dave Wurzel. You're watching PHTV4. You've been watching Ask the Attorney. We've been talking with Eileen Curlin Walsh from Curlin Walsh Law. Thank you for watching.